Jesus. You're live. Welcome, folks. Uh, By Justice Oversight Committee. It is July 2nd. I apologize. We are running a little late. We had to take care of some logistics here for the committee in terms of the cafeteria was closed today, so we had to figure out lunch because none of us knew the cafeteria would be closed. And also for folks who have been following along the Joint Justice Oversight Committee for a number of years, we spent a little bit of time here before we went on Zoom, remembering our chair, Senator Dick Sears. Senator Sears passed away about 6 weeks ago. We were scheduled to have a meeting on June 11th that Senator Sears had organized and set up the agenda. We postponed that out of respect. And this is our first meeting of this particular summer and fall. And I am vice chair of Justice Oversight, and we will be discussing later on today in terms of the leadership of our committee, how we move forward with that. But I do want to acknowledge publicly the amount of work that Senator Sears has done for us here in the Joint Justice Oversight Committee, but not just here for us, but also for all folks in Vermont. I've known and negotiated with Senator Sears for 30 years. And I have seen a person who is tough, but as Representative McFawn just mentioned that he can be a tough negotiator, but he does compromise for the good of the state. And Senator Norris also spoke and mentioned how much he's learned from Senator Sears and how walking into his committee room as a freshman senator was a little intimidating. But a lot of knowledge was transpired in the Senate Judiciary Committee. The thing that I always admired about Senator Sears is he could bring such a complicated issue down into simple terms and simple words that people can understand. And that is a true gift. So we will continue our work this summer and fall with some goals that the senator wanted to accomplish. We're going to depend on all of us here sitting around the table because we all worked with Senator Sears in different ways, so we can bring all of those interests and goals that he wanted for joint justice oversight for this year to be accomplished. So with that said, anyone want to weigh in at all before we start?
Madam,
yes,
Madam Acting Chair, I will say. You know, one thing I did want to say while we were live about Senator Sears is just something that was driven home for a lot of us that attended his memorial service in Bennington. You know, first of all, that he did that drive so often, you know, in sickness and in health was a huge sacrifice to the state, you know, for so many decades. And I'm sure he would have appreciated that we all had to take the 5-hour round trip drive to go down to pay our respects. But much more importantly, you know, I think people might have known this who served in his early days and watched him campaign, but many of us learned at his memorial service that he was born in a women's prison, you know, to a mother who had to make the difficult choice to give him up for adoption within that year. And I think, you know, he didn't wear that on his sleeve in terms of telling his personal story, but it clearly permeated everything he did, that some people are just handed a really difficult lot in life and they still deserve a second chance. You know, that everyone still has value and humanity. And it's just amazing, you know, that without really needing to tell that story all the time, or without, I think, many Vermonters knowing that story, nowadays, you know, that he really sought balance and to make sure that he wasn't on the side of victims or perpetrators, but that he was on the side of justice in everything that he did. And so I'll just always remember that. And it was really a tremendous honor and privilege to get to work more closely with him in the Senate. He's one of those people that I used to say, is he intimidating or am I just intimidated? You know, and so it's wonderful. The more you get to know him, the more you realize he really is trying to be as unintimidating as possible, or he was. And that was a gift for those of us who were able to sort of get past the gruff exterior. And I think a lot of Vermonters just know how much he's contributed and will miss him greatly.
We will miss him. And I do on a personal miss him greatly. So with that, I'm going to turn it over to our legal counsel, Ben Novogrodsky. Ben has been working on producing a document about our goals and responsibilities for the Justice Oversight Committee for these next few weeks. So Ben, I'm going to turn it over to you. We do have a document that this document's been posted on our committee.
I'm going to share my screen and go through it. 1 minute as I endeavor to do that. Presentation mode. Morning, committee. Somber morning. For the record, Ben Novogrodsky from the Office of Legislative Counsel. I used to staff the Senate Judiciary Committee too, so I have many fond memories of Senator Sears and my 3 years here so far, which I learned a lot and was constantly impressed in his willingness to see all viewpoints, bring in any witness that was requested or desired, and I think was an exemplary example of being a chair and a true people's senator.
Thank you, Ben.
I will listen as well. But on that note, welcome to the 2024 interim of the Joint Legislative Justice Oversight Committee. I'll go over just a reminder of what the committee's charge is, the work ahead of the committee, reports and updates due to the committee, and then some further discussion points for you all to consider. So just as a refresher, this committee is established under 2 VSA Chapter 23, has various powers and duties. It was an evolution, and originally was the Corrections Oversight Committee, and has evolved to be more than just that. But with that origin, its primary duty is to oversee the Vermont Department of Corrections, evaluate the strategic operating capital plans, policy development, and ensuring communication between really everyone involved in the justice system. DOC, the administrative branch, the criminal justice system, and also to assist with Vermont's juvenile and criminal justice system, including an evaluation of the statewide system of all pretrial services, diversion programs, really all restorative justice approaches, to identify any variations throughout the state, to assess consistency and cost efficiency of the various systems of justice in the state, ensuring that all statutes reflect restorative justice principles, which you'll see actually there's been progress with that, and then reviewing timeliness of judicial proceedings, which as members of this committee know, the court backlog has been hanging over the state for a few years now, but I'm sure you'll hear from Judge Zone, progress has been made cutting that backlog down. So any questions about the purpose of the committee and the work to be done going forward? Just going over the work and reports due. This is a lighter summer. I would say it's more normal and routine, because I think the last couple of summers have been quite there's been quite a lot of work to do for this committee, and not a lot of time to do it. So this is much more manageable from my perspective, at least. So there were two bills that were passed, S-195 and H-876, that required work to be done by this committee. Act 138 was related to bail and conditions of release, and charged this committee with evaluating the new pretrial supervision program. I'll get into details of what that review will be a little bit later. Act 159 was the corrections miscellaneous bill, and there's an earned time expansion review and recommendation that this committee needs to make. Because earned time was much discussed in the House Corrections and Institutions Committee about expanding it to include parolees, to include educational credits to be credited towards reduced sentences over time. So those will be the subjects of the study, and I'll get into more detail of that later as well. There are various reports and updates due to the committee as well. So it's not so much work per se, but it's reports and reviews that may prompt questions, witnesses to be brought in, things of that nature. Act 40 of last session, which started out as S14 and was entitled an act related to criminal justice related investments and expenditures. There were two reports that came out of this act. One is an annual report that's submitted by the Coordinated Justice Reform Advisory Council, which I'll describe in more detail later. And another, which is the first time that this is being reported, is really an assessment of Vermont's criminal justice related investments, and trends resulting from those investments, to really help evaluate the effectiveness of the investments in Vermont's criminal justice systems and if they're leading to desirable outcomes. And that report is filed once every 3 years because it tracks the recidivism calculation timeline in this state. So this is the first year of that, and then the next one will be 3 years after that. Any question on the Act 40 reports, or maybe wait till we get into more detail?
Just curious, when would they be due, or is that?
I'll get into the details. Act 125, which was S58, which was a much debated bill, but bi-monthly reports are due to the Committee on the Implementation of Progress towards Raise the Age going into effect next year. And then in Act 180, which was at H645, this established pre-charge diversion in the state, and there's a study about record retention. Who should be able to retain records? There was an exemption carved out in the bill or in the act to exempt law enforcement and state's attorney's offices from having to delete records. And this study was put in to see if, essentially to assess the appropriateness and when and what agencies should be mandated to delete records or not. So I'll get into the details of that report as well. So without any questions, I'll move on.
So just to be clear, in terms of what we are required, in terms of what we need to review, and then make recommendations to the next General Assembly, pertains to the issues within the pretrial supervision program and that bill, as well as the earned time expansion. Those are the two issues.
Exactly.
And then the others, all the reports, we just have to hear the reports, but there's no requirement for any action on our part
Right.
for that. But that's not to say if we do have some recommendations that we can do it, right?
Right. Yeah, there's nothing restricting the committee from doing anything. There's just no requirement to do anything with it.
The other thing I want to also bring, and Ben and I have had this conversation, there is another issue within corrections that it's not required of us to make any recommendations. It's keeping updated in terms of the replacement of the women's correctional facility. I know there's been a lot of work with members here in their respective committees about this. I know it's percolating that there is interest in this. So could you bring us up to speed in terms of what the requirements are?
Yeah, so on the new women's reentry and correctional facility, starting yesterday, actually, and going through January 1st, quarterly reports from the commissioners of BGS and DOC are required to be submitted to the institutions committees regarding potential site locations of state-owned land and any progress on purchasing things to either construct the facility or anything else kind of related to the development of the facility itself. So no requirement that those are due to this committee, but members of this committee sit on standing committees that are receiving these quarterly reports. So that requirement started yesterday. So that's something else to keep on your radar. And then there's also the secure residential facility. So this comes essentially again, the department or BGS in consultation with the Commissioner of Mental Health needs to report by February 1st of next year to various standing committees, the appropriations committees, the institutions committees, the health and welfare, or health and or healthcare committees, all need to be reported to. But that doesn't mean that the committee can't kind of keep tabs on things before that report is due in February.
And that was as a result of, was it S-192, which was the forensic?
No, that was in the capital bill. And
Yeah, so, but it's updating the secure residential facility to house folks who are
high risk.
not competent to stand trial.
Right.
But
And-
there may need to be some construction work within that facility to meet the emergency and voluntary procedure.
And there's a provision in that portion of the bill that says nothing shall be construed to prevent the development of a forensic facility in the future, but it's not really spoken to in the bill itself substantively.
The other thing too, and I think this is in S-876, wasn't it? In looking at shifting back to the women's replacement facility, kind of looking at the programming needs and the more internal structure.
Yeah, not, it wasn't for this committee,
Right.
it was the institutions committee, but yes, it was basically site plans for the committee, for the facility itself, how it would be structured, what services it would be housed. And so updates to the institutions committee were mandated for that, but again, not outside the purview of what this committee does and doesn't need a mandate to oversee that development.
So I just want to put this on the table for folks, because we're going to be talking later on today when our next meetings will be, and also what folks want on the agenda. And I would assume that some folks would want to get an update in terms of where we are in replacing the women's facility. I would assume that. So I wanted to put that on the table so people can think about that for our next few meetings for that. Thoughts, questions from folks? Anyone on Zoom? We can't see you. Can you see them, Megan? You can't, can you? Okay. Anything else? So let's keep going. Whoops.
Just Rep. Balon needs to drop his line off, so he's
Yeah.
going on.
Yeah, Martin's gone and back. Okay.
So the work to do this summer. Act 138, this was S-195, the pretrial supervision program. It did a lot of other things too, but for our purposes, it established a pretrial supervision program that can be ordered by the courts and administered by the Department of Corrections. Essentially, if someone is deemed a significant risk to public safety or has not less than 5 or more pending dockets against them, they are eligible to be placed into that program. And so there's a procedure about where DOC would essentially do an investigation of the individual, submit a report to the court, and the court would use that to either order pretrial supervision or not of the defendant that meets those eligibility criteria after doing an assessment of what that risk would be, or the dockets and the nature of the charges. And there's a whole host of considerations in making the determination. And also the type of supervision that can be ordered can range from automated telephone calls, just reminding people of court dates, to in-person phone calls, in-person meetings, Zoom or some other remote check-in, or anything else really that the department deems necessary to effectively supervise the individual subject to the program. But one issue within this was funding. And my memory is that there's about, I think it's $687,000 that was appropriated to this program. Don't quote me on that exact number. But that is insufficient to operate the program statewide. And so what this committee is charged with is to do a review of the program and provide recommendations to DOC for the most prudent use of those funds. And also to include recommendations concerning the areas in the state that the department should first implement the program, along with any future funding mechanisms for it. So that's the focus of the study. These need to be submitted to the department by September 1st, and then to the General Assembly by November 15th. The reason why that was staggered in such a way is because this program goes live before November. And so it's basically the department needs those recommendations in order to bring it live, and needs that information to implement it in various areas as recommended by the committee. And then also it provides time for the department to then come back to the committee and explain what they may need for the budget next year. And so that's why the November 15th deadline exists, is to give enough time for the program to kind of work for a couple of months, see how it's used, see what they need, and then enough time for a bill request or draft to be submitted to either revise the program or to allocate certain money, or to potentially even create new funding mechanisms for it. So that's essentially the charge on coming from Act 138. Are there any questions on that study?
So for the committee, this pretrial supervision program is brand new. Does not exist now. It is when someone is arraigned, basically, and after arraignment, they haven't gone to trial. It's a new thought in terms of beefing up public safety for when someone's out, they'd be out on bail.
On bail or conditions of release?
Conditions of release. Those would all be set by the court. Part of their condition of release could also be electronic monitoring, if the court so chooses. But the big piece on this is DOC would now be doing the supervision in the community. That's the big shift. Right now, there's really no pretrial supervision program, and someone could be arraigned, they're released on conditions. And basically by default, it's your local law enforcement entities that would be enforcing those conditions. If they see a violation of those conditions, they bring the person back to the court. This sets up a new program that DOC would do the supervision. And the concern that we heard in House Institutions Committee, and I think also probably Senate Judiciary heard this as well from DOC, was it's going to cost much more money than the 600,000. And
I think it was 1.2 million.
1.2, 1.5 million to put it in all their district office, field offices. So for 600,000 or 687,000, you basically may just have one field office that would be able to do this, maybe two. So the question is, for us, is we would be part of that decision-making with DOC in terms of what part of the state would have these services to start up. Would it be in one spot, one county, or could we spread it between 2 or 3 counties with the 687,000? That's going to be our recommendation, so that the legislature is also part of this decision-making, not just DOC. And then if it was just DOC, and then they didn't come forward with it, we could easily blame them for not carrying through the law. But if the legislature is also involved in that decision-making, then we have a say in terms of where this would first get rolled out, what part of the state. Does that make sense, folks? So that's going to be our role in this. So I would say our next meeting in August, towards the end of August, I would assume, we need to get a preview. We need to have an understanding of what the pretrial supervision program is. And then also discuss the dollar and where those could be expended, because we'll have to make a recommendation at our August meeting. Bob?
So we've got 60 days to submit to the department our recommendation. We're going to have one meeting in August, July, August, or September.
It'd be in August if we have to do it. Because September 1st, we need to submit the recommendation.
Yeah, but I'm just saying that there's a whole lot of recommendations being submitted with only like one meeting going on here. And if memory serves me correct from the testimony that we heard, I believe there was originally 11 to 12 positions, 12 positions originally statewide. DOC said we can't do that on $600,000 and change. So I guess one of the points is how many positions would that encompass? And I'd be looking heavily toward DOC's recommendations on this particular issue.
My recollection of what here is that the original ask was for 12 field officers, 2 administrative support staff. I think the 1.2 reflected having that number to 6 field officers and 1 support staff. And then the 687 doesn't even get us to that point. So, I mean, maybe 3 and I don't know, half a support person, but I'm being facetious, but you know, that's sort of the numbers that were being worked with before. And unfortunately, we really only have 1 meeting before you make it. There were supposed to be 2, but obviously we know why we delayed the June meeting. But this is really a continuation in a way of the discussions that were still ongoing really in the 11th hour of the session. And the bill itself did contemplate the scenario where you're not going to fund it statewide, because in the bill, there's a provision that says basically the court can't order this program unless it's funded. So there's not a mandate throughout the state to operate this program. There's not an unfunded mandate, essentially. It's only going to be operated in the areas that are funded to do it. And it seemed like, and I don't mean to speak on behalf of the department at all, and I defer to them, so please correct me, but it seems like they have a pretty good handle on what they need to implement the program. There was a lot of discussion also within the committees of jurisdiction about really where for lack of a better term, problem areas in the state. You know, I think there was a lot of discussion of Chittenden and Rutland counties, but obviously that could change depending on the committee's discussion. But I just want to give the committee sort of a lay of the land going into this. And these were the topics of discussion and the areas that were discussed ending the session, and hopefully will be picked up now.
We've got some work to do, and I know we're getting an update from DOC shortly, and maybe you could just kind of highlight this a little bit just to lay the groundwork for it, because it's an important program, but we may not be able to get it up and running as we had hoped. I know that Senator Lyons has come on board. We can't see anyone because
Do you want me to, I can stop sharing and that way I'll pick up after if you want to break for discussion.
I think we're fine. I think Senator Lyons, what we're going to do, we're gonna continue going through what our charge is for this next few months. And then what we're gonna do before we break for lunch, we're gonna have a conversation in terms of how we proceed with the leadership of the Joint Justice Committee. We had a little bit of discussion this morning. And the Senator, I think the committee is also thinking the same path as what you were thinking when you and I had a conversation at the end of last week. So we'll pick that up before we break for lunch at 12.
Sounds good. Thank you. And thank you for being patient with my schedule this morning. Appreciate it.
No problem. So Ben, why don't you keep going?
Sure. So the next task for the committee is from Act 159, which is the Corrections Miscellaneous Bill. So coming from Section 3 of the bill, the committee is charged with reviewing whether the Department of Corrections' current earned time program should be expanded to include parolees, as well as permitting earned time for educational credits for both offenders and parolees. So the current earned time program is only for doesn't apply to those that are out on community supervision. It's only those that are housed in a facility. And essentially, if they are on their good behavior, I believe for a period of a month, they can have up to a reduction of 7 days of good from their sentence for that good behavior. And so the discussion now would be, do you expand that to parolees? So people that are still that are out in the community, subject to conditions that have been imposed by I guess it's imposed by the parole board, or at least monitored by the parole board, and whether or not there's a way to implement the current earned time program as applied to parolees. But there was a bill this year about educational credits. This is modeled off of something that was implemented in Colorado last year, where essentially if someone, while they're housed in a facility or as contemplated by this bill, a parolee, if while they're incarcerated or under supervision, if they get some form of degree, either a trade certification or anything ranging from a bachelor's degree and beyond, if there should be a reduction of time associated with obtaining one of those certifications or degrees. So that's the idea to research there. This review also needs to include an examination of the current operation and effectiveness of the DOC victim notification system and whether it has the capabilities to handle such an expansion. And really that comes from, I think, testimony that was received this past session from the Center for Crime Victim Services and others, where they're not necessarily notified when there's a reduction in time because of earned time. And so there was a concern raised that if there are currently problems in the program as it is, perhaps it's wise to address those before expanding it to others and to other services. And so that's something else that the committee would consider. And there's a mandate to solicit testimony from the department, from the center, victims and survivors of crimes, including those that serve on the center's advisory board, and from the Department of State's attorneys and sheriffs. So those are all your featured guests, if you will, to talk about the victim notification system. And then this all needs to be done by November 15th of this year. And it's not a requirement to submit recommendations. It's just if you have them. So it's any recommendations, submit them to the Judiciary Committee and the House Committee on Corrections and Institutions.
So in order to try to figure out how much time to schedule for 2 committee meetings or 3 committee meetings, how many folks are familiar with the current on-time program? That's what I thought. Because I think in order to really understand this, you have to understand the current earned time program. So that's one thing we'll have to schedule in to earn time 101, as I call it. Because we have to understand.
It depends on the detail that you're asking about, but I don't understand the details. I forget. I know we passed the legislation not that long ago. It would be great to have a review.
But you have to understand those details because
Yes.
right now, earned time is only for folks who are incarcerated.
Yeah.
And folks who are on furlough. It's not for folks on parole. And we wanted it to also include folks on parole. The Senate did not agree with that. So they are looking to DOC, whether or not it should be expanded to parole, folks on parole, and for us to also look at that. And the other piece is right now for earned time, a person who's incarcerated or a person who's on furlough automatically receives 7 days off for each month that they served, unless there's is it a major DR for that? So the question is, if you add in educational credits for folks, and the thinking was if they're on parole, let's offer them earned time or more earned time possibly, if they're earning educational credits. So on the surface, that may look, yes, that makes a lot of sense, but what about folks who are on furlough? And you're not doing that for folks who are on furlough. And what about folks who are incarcerated? You're not doing that for folks who are incarcerated. So that's what we'll have to weigh out for that. And then you throw in the victim issue as well.
When we do the 101, it certainly my recommendations for those who may not be as familiar is to break down what furlough, parolee, everybody knows what incarceration is, probationer and all this stuff, just so that we get better understanding as to that
We
covers.
can do that too. We can lay that groundwork for that, because you really need to understand the current mechanics of how it works before you get into whether or not it gets expanded. For that, so that can also be.
And there are some thorny issues there as far as constitutional concerns with equal protection. Why are you treating one group differently than another? There needs to be a pretty good reason to do that.
It's pretty complicated in some ways.
Yeah.
Okay.
Any other questions? With that, I'll move on to the reports and updates that are due. So Act 40, again, both of these reports are due November 15th. Report on criminal justice related investment trends. So this is, as I explained before, the first report since this legislation passed. It includes data showing trends in Vermont's criminal justice system and really is an attempt to assess the effectiveness of Justice Reinvestment 2. Over the better part of a decade, if not longer, justice reinvestment has been implemented in 2 phases in this state. And it's really focusing on rehabilitation, diversions from the criminal justice system. And this report is aimed to show indicators of success for those initiatives. So specifically, we talk about recidivism rates, clearance rates so those would be things about whether cases have been closed by law enforcement, either through arrest, closed, or some other extenuating circumstance. Evidence of desistance. Desistance essentially means progress, for lack of a better term. So it's not that someone that hasn't recidivated. It can be someone that maybe was charged with a domestic violence felony when they were younger, but then they've gotten to the point where they're only committing misdemeanor retail theft. That would be evidence of desistance because they're not committing as serious of crimes over the course of their life, essentially. So it's a way to measure progress in that way. So there'll be indicators of that. There are going to be indicators of the money that has been committed under the JR2 umbrella towards transitional housing, drug programs, things of that nature. It's a very, very comprehensive report that's being spearheaded by the crime research group in consultation with many other stakeholders to get this right. And it's going to occur once every 3 years. And this is going to be the first year of that to see if the things that the state has been doing for the past 10 plus years has shown signs of success and if the investments have been worth it, essentially. Relatedly, Act 440 also created the Coordinated Justice Reform Advisory Council. The purpose of the council is really to establish a unified and collaborative approach to support restorative justice providers, and to make sure that the programs and services that are implemented are consistent with the state's restorative justice policy, which is in 28 VSA Section 2A. And this is, think of the council here as really the next phase of justice reinvestment. Justice reinvestment was managed and implemented by the Council of State Governments, of which Senator Sears served on the board. There's quite a close relationship with them, but their role in this has finished. And so this is the next step of the state essentially taking the mantle over to keep overseeing those initiatives and either improving them, changing course, or whatever the council shall decide. And what their report does here is they have to provide considerations and recommendations to establish a sustainable planning and funding structure to administer those community-based programs and restorative justice providers, along with modern data collection systems. So as you'll hear from the H645 report, these providers are all funded through grants. And right now those grants are issued through the Department of Corrections. H645 changed that so that the majority of those providers are now going to be issued grants from the Attorney General's office. But the problem with grants, as you will hear the providers themselves testify to, is that it's really hard to plan year to year when costs go up and baseline funding isn't truly baseline funding anymore because of those cost increases in inflation. And it's really hard to plan for staff, numbers, salaries, programs, services, when you're living year to year, not really knowing how much money you're going to get and whether that money is even enough to operate as you did in the year past. So these are funding issues that this council is supposed to assess, and will submit a report to all of you on what they find, if anything. The second portion of the report is to submit recommendations to the Commissioner of Corrections for the appropriate allocation of not more than $900,000 from the Justice Reinvestment to line item of the DOC budget for the upcoming fiscal year. And this would be to support those restorative justice providers and programs, the data collection and analysis and other initiatives consistent with the purpose of the council. This recommendation is due to the commissioner in September, so that can then be rolled in to the commissioner's budget ask that you'll see in the governor's proposal come the beginning of next session. However, it's merely a recommendation. It can be changed, it can be not withstood, but it was a nod essentially to say this is what the legislative this is what the stakeholders think is the appropriate use of the money, but ultimately it's DOC's proposal. So those are the two things that will come to this committee in that report.
So the real broad understanding of justice reinvestment and the work that we've done as a state with the Council of State Governments on this is looking at the driving forces in terms of our incarcerated beds, people who are coming into the correctional system, our facilities, and serving their sentence and then re-entering into the community. And where those points are that are exacerbating the correctional system, what are the drivers that are bringing folks into our correctional facilities? What are the drivers when a person is entering the community? And they come back into an incarcerative setting. So the work that the Council of State Governments did, they highlighted some certain areas, and in Justice Reinvestment 2 in particular, where this 900,000 is specifically to go, what Council of State Governments highlighted is particularly on the reentry piece, when a person is either on furlough, or they could be on parole, those support services that are needed for the person to succeed out in the community from our community partners. It could be supportive housing, it could be mental health treatment, it could be substance abuse treatment, transitional housing, those type of things. What the Council of State Governments found was that DOC was picking up the tab on this. They were paying for it when it should be our community partners should be paying for the services. So that was the goal, that in theory, for justice reinvestment, it costs X amount for an incarcerated bed. If you can invest that money into your partners, community partners out in the community to provide those services instead of the DOC nickel, it's going to save DOC dollars in the long run. And it's going to, because we're not going to need as many beds. That's the thinking. You invest those dollars that you have saved on a bed, you invest that back out into the community. That's the thinking for justice reinvestment. And is it working or not? We don't know. And we're going to get some testimony this afternoon from our joint fiscal office in terms of what monies have been put for justice reinvestment 2 over the last couple of years.
Yeah, and just to kind of elaborate a little bit more on the topics that are covered in this report, there's, I mentioned recidivism, evidence of desistance, but it goes beyond that. I mean, it's returns to incarceration from community supervision. That includes data points on what type of community supervision, be it probation, parole, or furlough, an indication if a return was for a violation of one of those supervision statuses or for a new crime, if it was considered a significant or non-significant, violent and non-violent crime, any available demographic information. It's also going to include bail rates, including detainees who are held without bail, held with bail, the monetary amounts, and those who post bail and are released. Also, pretrial detainees held in Vermont, classified by crime type and the jurisdiction in which they're held. And then the funding for and utilization of substance use disorder treatment, mental health, educational, and vocational initiatives for incarcerated folks. And then the funding for JR2, which covers domestic violence intervention programming within DOC, including the results from the evaluation framework that the Vermont Network Against Domestic Violence has partnered with University of Nebraska to develop. Offender transitional housing capacity, advancements to the DOC's data collection systems, agencies, departments, and other organizations who employ restorative justice principle, including community justice centers, and any other expenditures from the general fund for these initiatives. And then specifically on the out-of-state beds point, it will highlight information from DOC out-of-state beds that were contracted for by the department and the average cost of that bed from fiscal year 19 and for each year after, as well as DOC's in-state beds, which would be separated by gender, including specialty units. So units like there's an infirmary or maybe mental health unit, and then units that were closed or unavailable in a given fiscal year, again, from fiscal year 19 on. So these are the data points. It's going to be a lot of information to help you all assess, in addition to various other people that will be receiving this report about really what the state's been doing.
And see if we're achieving our goal. That's really going to be the key. Are we achieving our goal or not? Let's keep going.
So So Act 125, which was S58, bi-monthly reports on the Raise the Age implementation. So from section 12 of the bill, on or before the last day of every other month from July, so this month, through March of next year, AHS shall report to this committee, the Judiciary Committees, HCI and Committee on Human Services and the Senate Committee on Health and Welfare on its progress towards implementing the requirements of sections 7 through 11 of this act, which is really just Raise the Age initiative, which is scheduled to take effect in April of next year. So it would start the end of this month and then 2 months after that. So that would be what, the end of September, and then the end of November for those bi-monthly reports on the progress made towards implementing the initiative.
We should really be scheduling our next meeting in August to cover this.
Mhm.
And we have to do it again in September.
I mean, these are just progress reports. So, I mean, it's up to the discretion of the committee to actually schedule time here, or if you just want to receive the reports. It doesn't, however, does not specify that they need to be written. So that might be a point of inquiry, is to see how are these reports being prepared? Is it intended just to be an oral presentation, or is it going to be something that you could just look at?
Okay.
No questions, I'll move on to Act 180, which was H645. This is the record retention reports for pre-charge diversion. So in the new pre-charge diversion statute, to explain what pre-charge diversion is, it's under the current diversion program, you have to actually be arraigned before you are referred to diversion. This establishes a process where you don't need to be arraigned, but there needs to be evidence of probable cause as assessed by either a law enforcement officer or a prosecutor. Basically to make sure that there's enough evidence of a crime, you're not just referring people for no reason, to restorative justice providers. And if those people successfully complete the restorative justice programming or the diversion program, their records can be deleted, which, think of it as akin to expungement, except there's no court order in this process. Because when you have been arraigned, you're subject to this jurisdiction with courts. So rather than having the courts issue an expungement order, you're having the Attorney General's office issue a deletion order, since they are managing the diversion programs. And so they satisfactorily complete their programs, they notify the providers and the powers that be within 30 days of completion, and then 2 years after that successful completion, records can be deleted if there have been no other incidents during that time. But there are 2 carve-outs for the deletion for prosecutors and law enforcement agencies. Basically, prosecutors were carved out to meet their Brady obligations. So under Brady and Giglio, all exculpatory evidence needs to be disclosed in a case, and any impeachment material as well. And that includes law enforcement officers that may have had allegations of impropriety against them. That's something that is an ongoing obligation of a prosecutor in a court case. So if Officer X years ago did something that was improper and he was on this new case that's being prosecuted, that information would need to be disclosed. There was testimony that prosecutors could be hamstrung if they had to delete records of diversion that may include an officer's records or things of that nature. And so that's also why law enforcement itself is exempted, but only for private databases. So anything that's public facing gets deleted. They only can retain private databases of their own reports and records. But with that in mind, there was a lot of discussion about, well, is that really appropriate long term since this is a new program? And so as a result, on or before November 15th, the Sentencing Commission shall submit a written report reviewing the current record retention practices of the pre-charge program within law enforcement agencies and state's attorney's offices, and then provide the following recommendations: whether pre-charge diversion records are retained, sealed, made available on a limited basis to law enforcement prosecutors, or deleted altogether. If it's recommended that the records be retained, a determination of any time limits or other restrictions related to such retention. If it's recommended that the records be sealed, a determination of the circumstances that would permit such sealing. And if it's recommended that records be made available on a limited basis and the circumstances as well. And then finally, if records should be deleted and a determination of any time lapse or other considerations for prior deletion. So you see sort of a scaling here. You got to either keep them or keep them for a certain amount of time, or you seal them and you seal them for a certain amount of time, or they're just going to be available for a certain amount of time, or they're deleted but have to be retained for a certain amount of time. And we can get into the differences of, expungement itself, and think of it as deletion is as if the event or crime never occurred. Sealing is that it's not discoverable except by certain authorized agencies. And then, so those are sort of the terms of art there that we'll get more into as, if the committee desires receiving the report.
And I know Senator Lyons has a question, but prior to that, I'm going to be depending a lot on our Judiciary Committee members on this, because this is all more in their world than some of our world that we're familiar with. So heads up, be prepared. Senator Lyons?
No, yes, as Ben is going through all of this, and I'm including some of the prior discussion, there's a lot of information here regarding the availability of community services. So including in the pre-charge diversion program, this is more about reporting current records and retention practices that just does belong more in the judiciary environment. But we've also talking about mental health services, substance use disorders services, and AHS will be reporting to us. So I think it's absolutely key that as there's any discussion about any expansion of services or how are we meeting our current need for pre-charge diversion, just a heads up for us. I think the demand is very great right now in the community, and it would be good to know who is available and who is providing those services, and what pressures are they under, if any.
And Senator Lyons, on that note, I have information, and I know Amy Pope has information on a list of all the providers. I do know that there's been contact with DOC, the Attorney General's office, and DCF. They're all the entities that essentially handle these issues, or oversee them rather. Another thing that came out of this act that isn't necessarily before this committee explicitly is that the Attorney General's office is charged with data collection, because there isn't a lot of good data from the providers themselves about the number of referrals that they handle each year, the rates of success, rates of failure, who and what are being rehabilitated in these programs. So this is there are reports that are going to be submitted to the various judiciary committees, at least, on that information. I want to say it's in January of each year, but it's in the bill, and there will be more data. It just isn't necessarily mandated to come before this committee. But it's, as you can sense a theme in this presentation, there's a lot of data collection going on right now. And that's in an effort to assess the successes of what the state's been doing.
Or failures.
No, thank you. I mean, it does have implications for the organizations in our local towns and municipalities that are providing some of these services, so that the data will be extremely helpful.
So let's keep moving here. I know we're running late.
So that's the end of reports and work due, but I wanted to create a slide on considerations moving forward this year and next year. So H645 did mandate some reports due to this committee during the 2025 interim. This is mostly for me as a placeholder, so I don't forget about it next year when I go back and look at this presentation, but figured I'd throw it in here for you all as well. And this is another thing having to do with, once somebody has been adjudicated, found guilty and sentenced, what are some sentencing options that can be imposed that are restorative and reparative in nature? And so there was a post-adjudication working group convened to make those assessments and recommendations, July 15th of next year, with a report due on November 15th of next year. Another one was a study on criminal record sealing. This was a priority of Senator Sears that I know he was very adamant about this past session. I think Representative Lalonde can probably speak to the passion with which he wanted to study this. But this was something, again, in his honor, essentially, for the committee to consider as a work to explore, and is related to the H645 study about record retention, since sealing is one of the considerations that can be contemplated. And then any other priorities that are hanging out there from the committee, we recommended, or we discussed earlier, the forensic facility, the secure residential facility. So those are other things as well.
We'll have some time as well in the committee to talk about what are some of our other priorities so that we can start scheduling that up. Next meeting.
And then last but not least, just a quick reference of the schedule for the summer.
And that's the other thing we'll do today before we leave, is try to figure out when we should meet again. I would suggest probably towards the end of August, get through the primary season and then go from there. But we need to figure out what days of the week. I know for some folks, certain days don't work, and that would be really helpful to have that before we send out a doodle poll. Anything else for Ben before we move on for updates from DOC, which is going to be a little truncated, but we just had lunch delivered here, so I would go over 12 o'clock. Over noon now. Anything else for Ben?
Madam
Yeah.
Madam Chair. So I just, in terms of the big picture of anything else, I was starting to write you an email, but I thought I'd just say it so it doesn't get lost. You know, Senator Sears and I were having lots of conversations about different ways to keep people from having sentences that might not fit the level of crime. We talked about ending life without parole. And in that conversation, he said, you know, that he felt, and I don't want to, you know, try to revive his words exactly, but that, you know, more important to him, or just thinking about more people impacted, was 3 strikes laws. And I just plan to sort of look into that more. I don't know if Senator Norris or anyone who was on judiciary with him heard him talk about that, but he was becoming very interested in people who might be over sentenced or sort of sitting in jail without rehabilitation because of 3 strikes provisions.
We don't have 3 strikes, you're out. And we have, is it, we do have something, what is it called? Repeat offender? What is it?
Visual offender, yeah.
Visual offender.
Yeah.
Let
Which
me
there is.
find, yeah, I'll find his email and forward it, because it was, you're right, it wasn't articulated that way, but this is where I'm not on the Judiciary Committee, but, you know, I'm trying to sort of reflect back one of our final conversations about, you know, people he was worried about as a population in jail. So I'll look for that email and I'll forward it to some of you.
What was he talking about? Folks who were pretrial and being kept in by the Department of Corrections? Because that was a concern.
I mean, that probably was for him too. And again, we don't want to sort of like overstate where he was, but I'll find the email so I'm really specific. It was definitely post-trial, post-sentencing people who are sort of, you know, are we worried they're just sort of in in prison. And he said was always sympathetic to the life without parole piece, but he was more concerned about this larger group of folks that, you know, may have been sentenced beyond the nature of the last crime they committed. And I'll find the email.
Yeah, if you could find that email,
yeah.
that would be very helpful, and send it to all of us in the committee as well as Ben, so
Mhm.
that we can kind of figure out what was the concern.
Will do.
Anything else for Ben before we move on to DOC here? Okay, thank you, Ben. We got our work cut out for us. It's not as heavy as in the past, but it's heavy.
Out of the hot seat though. Out of the hot seat though.
Out of the hot seat. Or Al or I, somebody.
I think Al will go together.
We got more hot seats now. We'll spread the warmth around. So there is a document that you have, and also sure that there might be some questions coming from the committee, because, you know, with the hot weather that happened a couple of weeks ago, there was a situation that happened with our correctional staff that members might want some clarity on as well. So welcome. And we can go a little bit beyond 12 o'clock if we need to, seeing that we had our lunch brought in. And so I'll turn it over to both of you folks, and if you could just identify yourself for the record.
Kristen Calvert, Deputy Commissioner, Vermont DOC.
Al Pena, Chief of Operations for the Department of Corrections.
Okay, which one of you is going?
We can talk about the population overview, first slide, just to kind of set the base for where we're at right now with our population. With this slide, you'll see we're starting to see a slight increase of our numbers. For pre-COVID, we see where they dropped drastically. In the last 10 years, we've seen quite a decrease. The numbers we start to see increasing though are those detainee numbers starting to rise again.
548, that's the highest we've ever been.
Absolutely.
So when we were here in the building over the session, it was running around 425, 450. So is this a seasonal bump or what?
No, you'll see that it's started, you know, mid 2021, 2022, it's really started climbing up, and I wouldn't consider it a seasonal bump. I think it's a reflection of the courts finally starting to open back up, getting back to more regularly scheduled arraignments. We're seeing that population come into our facilities.
And our population is now over 1,400. Now this includes the out-of-state beds as well.
Yes,
And this is our whole system, male and female.
correct.
How many, you have it broken down by how many detainees are in the women's facility?
Not in those slides, but we have 520 detainees, 440 state detainers, and 80 are federal.
Say that again, there's 500.
Sure. 520 total detainees,
Yeah,
440 are state detainees,
yeah.
and 80 are federal.
And so you don't have it broken down, how many of the 440 are women?
53 of them are women.
Thank you.
And what's your population in Chittenden right now?
117.
Was the first one? 520?
520 total detainees.
So half of the women's population pretty much are detainees. And even in the male population, that 909 that are total sentence, those are just state and our Mississippi folks. That's not including federal folks that might be incarcerated.
We have no state or no federally sentenced individuals, just
Right. Those detainees. So of the 440 state detainees, that's almost half, not quite half of our incarcerated population are detainees. That's always been a concern, is the increase in our detainee population. Is there a little deeper dive in terms of those detainee numbers, that some of those folks are already sentenced and they've created a new offense and are being detained? Would they be considered a detainee?
But 92% of our detainee population is felony level detainees. 94% of the Senate's population are felonies. 60% of the detainee population is Big 12 offense, aggravated assault, sexual assault, murder, felony, serious, what we classify them as.
So if a person has an underlying sentence and say they've been on furlough, they're on parole, and there's a new offense, and then they're reincarcerated, are they considered a detainee or are they considered incarcerated? Both.
We consider the status we call them is a sentenced detainee.
So would they show up in that 440?
They would show up in the, yes, the 440 is part of that thing. No, the 440 is straight detainee.
Straight detainee,
No sentence.
first time really incarcerated. Questions? Any questions on the incarcerated population at all? So 92% of the detained population are there for felony charges, and 94% of our sentenced folks are there for felonies. Want to put that out there. They're not misdemeanors.
They're not. Gone are the days of the back checks and DWI ones, and so forth.
And how does that jive with the discussion about somebody was worried about people that were in prison?
The one that Keisha brought up.
Yeah.
In terms of what's their length of sentence based in
Yeah.
terms of the crime that they committed.
Right. If 94% are felonies.
That's why I think it's important for her to send that email,
Yeah.
so we
okay,
can refine that to see a little bit more.
Okay.
We could certainly break down that sentencing information too, as to what the sentence structures are based on the different charges.
If folks want to do any deeper dive on any of this, we can do that. We just need to know so that we can schedule the time. Ben has a.
Just a point of information for the committee, without knowing what that email is, the vast majority of criminal laws in this state don't have, they state a range of sentencing. There aren't like, mandatory minimums or anything like that. Typically, there's just a cap on it, and so it leaves the judge a lot of discretion given various factors to consider.
So it could be minimum 10 years, next one.
Yeah, I believe I'm only seeing a minimum of that when it comes to like homicide related crimes. But most of the time, it's just, not more than 3 years in prison and a fine of $1,000 or both. That's typically how the general structure of our criminal statutes are. So it just puts a cap and then doesn't really necessarily have a mandatory minimum. The other thing to consider too is, I Haley this on the side, but H645 created the pretrial supervision program and also an expansion of home detention, which was specifically meant to keep people out of prison. And so that might be something to consider when analyzing these numbers. The new home detention expansion is only for those who, not only those who can't make bail, which was the current program, but was expanded to those who pose a significant risk to public safety. And that went into effect June 1st. So we're only about a month in of that program, so I don't know if it's had any effect, but that's maybe a point maybe to keep track on throughout the summer.
Currently only six individuals on home detention statewide.
Well, you went up. We had 4 back in May. Now you went up.
On the rise.
On the rise. So the goal of home detention is not to take up an incarcerated bed. They're detainees, but they're out in the community. They're in an appropriate housing and they're monitored with electronic monitoring. And they're overseen by the Department of Corrections. Up top. To forget your question?
No, just remembered it. Do we have an accurate figure on the number of individuals of color that are here in the state of Vermont?
That are incarcerated?
I believe so.
Like, incarcerated,
Oh,
Just the
the
general
population,
population.
yeah.
1%?
Because in here it says 17% people of color.
Yeah, I don't know that off the top of my head. I do know it exists, but I
Is
do
it
know.
6% of our population or is it 1%?
That seems high.
Is it 1%?
Pretty low.
I do know anecdotally that.
Three
we
or
are
less.
on
It was 3 last time I checked, but that is.
3%?
Chair, I can comment a little bit. I think one of the major drivers of that discrepancy is that we are in Vermont incarcerating and, anyone who the court has sent us, and they may not be a resident of the state of Vermont. So it's not uncommon for folks, and it's disproportionately who are out-of-state residents who are incarcerated in Vermont are more likely to be individuals of color.
So there's a lot of what I would consider epidemiological type information that would be helpful here. And, I think Topper's comment has raised it, that might include how many of these charges or convictions are related to drug sales, distribution. So what types of charges are we looking at? I see the aggravated assault and sexual assault, but are any of these drug related? Just trying to sort out where they're happening. Yeah.
Show that.
Okay.
Hey, Sean,
Yeah, I didn't know if there was more to answer Ginny's question, but I just want to say people of color is not a race. We really need to know how many Black people are incarcerated, how many Black men particularly. Those are really different statistics than just saying white and people of color.
That information is available on the GOC website as well, and it's linked below.
And it will also be in the Act 40 report, and it's based off of any available demographic information, because there's a lot of testimony just about different capabilities of different agencies to gather that information. And then there's an added complication to that data point, which is it perceived race or actual race? And I believe that the Act 40 report is based off of perceived race of the officer. So it's, data can largely be imperfect, but it's also sort of the best that the state has at the moment.
Yeah, I completely agree. And I was there for, ensuring that we did perceived race, because that's still very critical information. And, when we know that places in Southern Vermont pull over in Brattleboro, for example, we heard 9 times more Black men are pulled over than white men. And in Bennington, we've heard that 75% of those pulled over are Black men. When we just hear, oh, they're from out of state, it just really concerns me that we're not getting to that epidemiological level of understanding, what patterns exist here, and especially just saying people of color doesn't do much for our oversight process.
Sure, we'd be happy to bring in more information on this, Senator. I think also that these would be good questions for law enforcement, state's attorneys and the courts as well.
Yeah, because you're the back end of it.
Right. We can give you the information for folks currently in custody, but for other populations who are criminally involved in the legal system, that's really beyond our jurisdiction.
And on that point, the entity that was charged with really gathering all these pieces of information together, so this is not the Act 40 report, which will show that as well, is the Office of Racial Equity. 2 years ago, they've been charged with really surveying state government and pulling all these different data sets together to show a truer picture. So that's another resource as well to go to. They theoretically have been doing that for a couple of years.
I don't want to lose sight of my other question regarding involvement with drugs distribution, and then in addition, any of those charges related to mental health issues and mental health needs. It's a significant issue right now. That information is also critically important.
So that information is available on our website. I would just know 3.4.
Okay.
Our population right now is incarcerated for drug charges and they're all felonies.
3.4%.
Yeah.
What about age distribution? And I'm sure you have that as well.
Yeah, if you follow that link below, there's a lot
Yeah,
of information.
okay.
So,
Got it.
And again, Senator Lyons, that will be in the Act 40 report as well, all of that breakdown.
Oh, that's so something to look forward to. When that comes one in November. It'll be Christmas gifts.
Nice to see you.
Thanksgiving discussion.
I just have a quick question.
Yeah.
When you say 3.4% of the
Yeah.
population, what's the hard number on that?
%3.4% of 909.
$30.
$57. Yeah.
that's just.
Thank you.
So what is that, Ernest?
57.
57 folks are incarcerated for drug offenses. Those are your sentence folks, right?
It's both. That's
Both sentence and detainees. So it's 3.4% of 1,400 people.
Yeah, the way it's usually classified too is that's they consider the driving charge, driving conviction.
Yeah.
Oftentimes, of course, with drug crimes in particular, you defer to state attorneys here, but there are other charges oftentimes involved as well. And so, perhaps an aggravated assault might be the driving charge in that particular instance. That's what's seen.
Keep going.
So we're happy to talk about our strategic plan we recently rolled out. We're in the process of,
It's larger. Oh, it's the big plan.
it's the one page and then the pamphlet has additional information in it. But over the last couple of weeks, we've been visiting our facilities and field sites. Engaging in focus groups with our staff around our strategic plan. Our strategic plan has four priorities, those being staff and staffing, health and wellness, diversity, equity, and inclusion for a just system, and modernization of our system. Each of those priorities has a steering committee attached to it. The steering committees will be responsible for engaging with our staff and community partners and meeting the goals and objectives of our strategic plan. The strategic plan is basically our roadmap for the next 6 years, taking us to 2030. Again, the plan was built with input from our staff from the ground up. We brought in staff from across the department, created focus groups or work groups, and those work groups created our plan. We brought that out to the field and facilities, created focus groups, took that feedback, created the final plan that you have in front of you. And now we're engaging our staff with that work. The intent of this plan is to really streamline what the department is doing and give us a document that we can refer back to for goals, initiatives, projects that we may become involved with that we can tie back to our plan. You know, the modernization is a big one, as we talked about in the women's facility. Talk about Wi-Fi in our facility, which is a major hindrance to modernizing a lot of the work that we're trying to do, whether it be better management system, electronic logbooks for our staff, updated camera systems, monitoring systems, and so forth. And that also impacts the health and wellness. The health and wellness of our population is a priority when it comes to healthcare and, again, modernizing our system. So there's an overlap with many of these with one another. The staffing and modernization fall heavily upon one another. But the goal of those steering committees is to ensure that there is a collaboration of services, not a duplication of services. So we want to ensure that two different work committees aren't doing the same thing, that they're communicating and talking and streamlining the process as we roll this out.
So who makes up the individual steering committees? Is it just central office folks, or is it also including correctional officers, administrators, superintendents, field office folks? Who makes up the steering?
So the steering committees are headed by 4 individuals. Kristen is overseeing the health and wellness steering committee. Isaac has the modernization steering committee. Jim Rice, our director of office standards and compliance, has our staff and staffing. And then the diversity and equity and inclusion priority is overseen by Glenn Boyd, a district manager in Burlington PMP. The chairs of those committees then have 6 around, I think we're at approximately 6 individuals on each steering committee that are made up of district managers, superintendents, and division directors from our central office. So we intentionally created the steering committees of higher level staff that can really, that can come together and bring those work groups together from the supervisory, manager, and line level staff as we roll these work groups out.
And how long have they been in this? They just get formed? Who's steering?
Just barely formed. We have a meeting next week with the entirety of those steering committees to talk about our goals going forward and what work groups and the planning may look like as we move this forward.
Well, those steering committees will line staff, your field officers as well as your correctional officers have access to these steering committee members. So if they see something, they can go to the respective steering committee.
Yes. Yep. I think one of the big things for us is the staff built this plan. It wasn't figurehead, the central office just saying this is what we need to do. The staff built this for us. And I think it's important that the staff roll this out as well, that their voice is heard, because they're the ones that are going to be impacted the most by this. So they will certainly have a seat at the table and a voice at the table when we do this. And the intent is not to create additional work, because for a lot of this, the work is already happening.
Mm-hmm.
It's involved in our pretrial supervision pilot that we're going to be talking more about. It's involved in our OMS upgrades and development. So we're gonna use this as the work and hopefully decommission some work. We've historically been really good about creating work, but not taking work away. So we're hoping that as we talk about modernizing the system, we can eliminate a lot of the unnecessary paperwork and processes that we currently do in a more streamlined fashion.
I know that we're gonna get some kind of a report from the agency that's providing the healthcare services.
WellPAC or
Yeah,
healthcare is going to be an issue.
yeah. So we are gonna get that, right?
I know Senator Lyons shared with me, we're going to talk later on today in terms of what other items we want to schedule testimony on. And I know healthcare is one of those issues.
Yeah, okay.
That-
I've got some follow-up questions that I want to make sure from the last maybe
Your-
3 or 4 meetings that we had to find out what's happening now in terms of drugs being provided to people in the prison appropriately, and then the transition coming out of prison, making sure.
We did that, and yeah,
I don't be the last. It's just
That's
the
an
point of a lot of discussion in the
Yeah,
House
that-
Corrections Institution, it came out of 876.
Yeah, right.
To revise and revamp, and so now what the mandate is that provider well path or facility, if someone is receiving prescription drugs, so non-substance abuse treatment, just any prescription,
Right,
they, before they leave this facility, they need to be, I believe, supplied with
30
up
days.
to 20 days of supply in hand with a voucher to redeem a prescription in the community once the supply has been depleted. They also have, can be put in contact with care providers in the community. There's sort of like a case manager, for lack of a better term, mandate to help coordinate and schedule those things. And then for the opioid use treatment drugs, I believe that was also bumped up to not more than 28 days. Or
No.
Legally permissible.
legally
supply.
permissible supply. Yes.
Until they can hook in with a hub.
Until they, yeah, exactly. So it's whatever is medically prescribed and is deemed sufficient by the physician. And then similar language about coordinating with in treatment centers, rehab, what have you. So
and that's all well and good. And I know about that. What I want to know is from people that have come out of the prison, that is actually happening. Because we were told before, oh, this is happening, and then we found out it wasn't. So I want to make sure.
And that's gonna take some time to get that kind of testimony. because
Well, I think we could just
it's
start there.
effective July 1st.
right, yeah, and there is language, sort of qualifying language that if the supply is available. Because one of the concerns that was raised in testimony was the ability to actually obtain some of these drugs
Yeah.
by the provider. Because I mean, anecdotally in the news, you can see that there are drug supply shortages, and so that's something that was accounted for, so. There is almost an out, if you will, that if they can't get the supply, they're not gonna be mandated to provide those to the people re-entering the community, just because they can't get them.
So what happened? What happens to that person?
Well, they do a prescription, they have to have a prescription.
And there's also
Go from there.
the 10, 11, 15 waiver that's being worked on right now.
Yeah.
But I don't know, I think you probably can speak better.
So-
to the
No, we
process.
actually that queued up in our.
And we're gonna spend more time on
Yes,
that, but the issue too, Tucker and other folks, you have to be, that this came out in testimony before our committee when we were looking at the reentry piece for prescriptions. And WellPat has in their contract that they provide
Right.
they provide a 30-day supply, however that gets done.
Right.
The issue that really came to light in our committee is that's all well and good if someone's incarcerated, they have a sentence and they're due to go out on furlough or they're due to go out on parole. DOC and WellPath knows that there's a certain time there that they have to get this done. If there's a detainee and the person goes to court, they could be released from court. WellPath and DOC has no clue. So if they're a detainee and they're on medication, they wouldn't have that 30-day supply because DOC is not in control. The person would be released from court and never seen again back in the facility.
Yes, and we knew about that.
And that is more of an issue that's harder to get your hand around.
Right, and we knew about that. With all due respect, I thought we were gonna try to figure out how to fix that.
The
problem.
detainees is very difficult. We fixed it for folks who are incarcerated and are sentenced. But the detainee population is difficult because they're there for a few days or they're there for a couple months or they could be there for a year or two. They go to court and then they're released.
And the judge released. Yeah.
And there was testimony too that really, I think a loose marker of time is like, it takes kind of 6 months, I believe was the testimony, to really make these assessments and get what you need for these people. So if there's someone that's just there over the weekend before they get rained, there's not enough time to
There isn't enough time.
logistically do everything you need to do to get them what they need.
Well, okay,
So we'll do it.
we'll do
We'll get
it.
more testimony on that, but those are some of the nuances. So when you hear from constituents and say, I can't get my meds, the first question that we should really ask as a legislator is, what's their status? Were they a detainee, or were they sentenced? Are they out on furlough or parole? Because then that gives you a clue. If they were a detainee, chances are it's gonna be very difficult for them
Yeah.
to have the medication. If they're on furlough and parole and they don't have the medication, that's something we can look at. For sure.
Okay.
So let's keep going here because we're running over time. Lunch is here.
I mean, we have a whole bunch of stuff we could talk about, but I want to make sure you hear what you want to hear.
Why don't, instead of you folks going through page by page, is there anything from members as you flip through that comes up at all? For folks, why don't we do it that way? Because I know we're running a little short on time. But is there anything that comes up if you look through the documents really quick? Anyone on Zoom? We can't see you at all.
I think, well, you know, Alice, I think the health issue, and coverage is going to be a topic that we'll want to dive into. So seeing the numbers is helpful at this point, sort of introductory. But I think we're going to have to come back to it in depth. And my internet is going in and out, so sometimes I lose you.
Oh, no. So in terms of, this is and you may not be able to speak too deeply about this because there's a suit that's going to be filed, but the situation that occurred during the heat wave with some of our correctional staff and heat exhaustion, or can you explain a little bit more maybe what happened? Were the folks within the facility, the building themselves, or were they out in the rec yard? How many officers?
Yeah.
And then also talk about where we are in the process that you're aware of, you're not in the driver's seat, about installing air conditioning within our facilities and the cost of that for the system. Okay.
So sure, I can certainly speak to that. I know there was a report that there were 4 correctional officers that suffered from related illness. We're aware of 2. We're only aware of 2 individuals. One of the individuals that was reported was a separate medical issue, not heat related. Part of the issue in the Springfield facility without the air conditioning that happened is we're under construction down there, the door control, and there's a lot of electronic upgrades happening, which then interfered with the electricity and the power supply to the air conditioning unit in the infirmary. So that was down for a short amount of time, because historically the infirmary is an air conditioned space within that facility. The administrative areas are air conditioned, the infirmary is air conditioned, the living units are not air conditioned. So working closely with BGS, we get that fixed in the infirmary. I think it was the following day or that night. But the truth of the matter is the facilities are hot. They're cinder block and concrete and steel, and they're hot buildings with very minimal ventilation. The superintendents at each of those facilities, the 4 that do not have total coverage of air conditioning, they're purchasing fans, they're purchasing cooling vests. We started this discussion during COVID when Commissioner Baker was on board. We bought the cooling vests, we invested in lighter uniforms for staff. We replaced all the uniforms that our staff had that were heavy cotton, bulky. So they're all wearing a much lighter, breathable uniform now. Staff are allowed to, we purchased polo shirts that are more breathable athletic fabric for our staff, so they have that. There are air conditioned areas that they can go to and break rooms and so forth. St. Albans, they purchased a misting station. I know one facility purchased a slushy machine, so we're getting a nice ice cold slushies for the staff. So, you know, we're trying to be as creative as we can until we get the project off the ground with installing air conditioning throughout all of our facilities. Right now, Marble Valley and Chittenden are the only ones that have full air conditioning throughout.
So in the capital bill, we did put in $5 million, and that the bulk of it is Springfield, but also some of that could be used for other spots within some of the other facilities like break rooms or visiting rooms for inmates and their families.
Some of the antennas, like those mini split units in a visiting room that currently doesn't have it. Part of the challenge there, though, is concrete and rebar, trying to find an appropriate accounting for those units. But that is the antennas to increase some of that until the larger projects can be completed.
And to air condition all of our facilities, the remaining facilities, I believe the number was around 20 million.
With Northwest being the most expensive by far, some structural work to be done. But Chair, as you know, Southern, where we're hoping to start this work, as Al mentioned, is our newest facility. And it is not fully air conditioned. And I think that goes to show that the existing infrastructure that we have as a state is inadequate. And that we are trying to reimagine a new future of our correctional facilities that really meet Vermont's value. And I think having air conditioning is a key component of that.
Anything else from members that are triggering? Folks got off easy, so. Anything else? So that's,
There was a slide on hospital coverage for field sites. I don't know if you want to touch on that, because that's
why don't you quickly do that?
hot topic.
I just wanted on the, Madam Chair, on the heat wave, or sorry, heat question, as we face more heat waves, I've been hearing FEMA and the federal government are trying to make heat waves is one where you have to be much more proactive in the funding that you provide rather than reactive. Have you been talking to the federal delegation about assistance in the climate transition with AC from the federal level?
We have not.
No, didn't know that was an option, frankly.
You might want
So
to,
we can do that.
Yeah.
because it's a heavy lift just to do it on a state level, and I think time-wise, like, when I read Digger this morning, and I don't know if this date was accurate or not, but for the air conditioning unit in Springfield to be up and running won't be until 2027.
I think we're 20, yeah, I think
That-
we're hoping 26, 27. It's a ways out.
That's 2 years out. I mean, it's 3 summers. I mean, it just doesn't seem it should take that long. But I know you're gonna have to probably move population, shift out the units, that type of thing. But the time frame seems pretty long.
Has there been any assessment of the need? I mean, obviously you're talking about the need because it's very hot in these buildings. But have you looked at or worked with Efficiency Vermont or utilities or others around heat pumps and options that might begin the cooling process?
Yes,
And cost analysis.
that is some of the work we have done, Senator, and working with BGS. I mean, this really falls on BGS more than it does us, but those conversations are ongoing with them around like the heat pumps and so forth on how we can get into some of the smaller areas in our facilities.
Okay, thank you. Yes, this is a concern. I think, this is something probably that has to be taken up.
So why don't you go into the hospital coverage here real quick?
So hospital coverage, you know, has been a hot topic, starting with COVID, staffing challenges and moving people into hospitals and having to provide that coverage with the staffing challenges that we face. We had 314 emergency room visits so far in 2024, to put into perspective the challenges that we're facing with our aging population and an increasingly sicker population. 2023, we had 532 ER visits, so we're on track to exceed what we had for emergency room visits last year. You'll see on this slide where we're covering the hospital coverage. We did some research and looked at how we could potentially cover these slots better. We created our central operations team, which is a team of 9 individuals currently that their primary role is only hospital coverage. Specially trained team throughout the state to deploy when needed to cover the hospitalizations of our incarcerated population. You'll see in this pie chart where we've covered, this is November of 23 through May of 24, where we covered 8,688 hours of hospital coverage for our incarcerated population. The majority of those hours being covered by the central operations team. Part of the challenge with this is we don't know when those people will be coming out, right? So it's not like we can plan to say we need 6 people on shift for this. It could be this week we have nobody going to the hospital. Next week it could be 7 people going to the hospital. And then that's where we run into those challenges of that coverage and still having to lean on the field for the coverage. You'll see that probation and parole officers covered about 11% of those hours. Volunteers and facility staff covered a combined 13% of the hours. So the hospital team is doing its job. It's reducing that burden on the probation and parole staff. In order to further alleviate that burden, we've added 2 more positions. We're currently recruiting for those positions now. Last I heard, we had about 30 applicants from across the department that had applied for those 2 positions. So those interviews will be happening within the next week or so.
So this hospital coverage is really, it's also more than just ED trips, correct? I mean, these are for folks as well that are admitted and might be there for a week or 2 weeks. And if they're admitted and they have to be there for a week, do you need 2 correctional folks on staff or just 1 or not?
Historically, we try to stick with 1 person, and it's a lot of it is dependent on the risk of the individual. The charges, a detainee that's on for murder that has a risk of flight, we'll probably have 2 people on there. Somebody that is non-ambulatory and we're comfortable with 1 person, where that's fine as well. So it's a case by case basis on how we provide the coverage depending on the risk of the individual.
So is that coverage 24/7? They're admitted and it would be right outside their room or?
In their room.
In their room.
How does that work? 24 hours a day, 1 person.
1 sheet.
2 12-hour shifts. So 1 person covers for the 6 a.m. to 6 p.m. and then another
Oh,
person
so
covers.
2 people.
Yeah,
Okay.
yeah.
These are things that we don't think about in corrections, but even when someone is transported for a medical appointment, are you having 1 officer or 2 for that transport?
Depends on their custody level. Minimum custody requires only 1 person. Medium custody and above requires 2 people. Federal transport require 2 staff who are armed per federal regulations.
So these are the nuances that we don't even think about that corrections has to deal with. Anything else before we move on to one other item that's not connected with corrections, but connected to us as a committee? I will get this taken care of before we break for lunch.
Just got a quick question.
Yeah.
Just out of curiosity, those individuals who are in state custody, are they able to be restrained using soft restraint, or there's no restraints whatsoever while they're out?
They're restrained in the hospital. They'll require, obviously, if they're going into an MRI or surgery, we'll often remove the hardware. But again, it's how ambulatory they are and what their behavior is like in the hospital. But usually it's one restraint to the bedpost and an ankle.
Right?
I don't know if this question has to do with, thank you, Mrs. Chair. I don't know if this question has to do with population or what, but I'll launch it. It came from a Vermont resident. Last year, several assaults occurred in one of our cities. Last year, the perpetrator was sentenced to serve 30 days of a 9-month sentence. Yet the guilty party was spotted back out on the streets that same day on parole. The question is, are we paroling people because we don't have enough space to house them in prison for 30 days, or why else would someone let go?
So I think to answer accurately, I would need a lot more information on the case and the specifics. But the parole board has the authority to parole at their discretion, not our discretion. So that decision to parole somebody would be on the parole board, not corrections. There could be a credit for time served, 0 min sentence, and they're automatically eligible for release. So there could be some different nuances on why that happened.
Because this is credit for time served. If they're a detainee and they could be there for a month or 2 months or 2 years, that gets calculated that they've already got credit for time served. So say they've been there for 2 years, they finally get sentenced to 5 years. They've already served 2 years, so they'd have 3 years. So in that particular situation, the person could have been a detainee for 60 days.
Credit for time
The
served.
person was set there to be incarcerated for a particular times. So that's another nuance for corrections.
If you want to introduce Aviva, we have our new
Yeah.
director.
I would love to. Aviva Teva's on the Zoom call. She's our new Executive Director of Health, Wellness and Engagement. So you'll see her whenever we call in WellPath or talk about health at all in our system. She's working really closely with us on a lot of community engagement projects, the Turning Point Center, the 1115 waiver, in partnership with DEVA and the Vermont Chronic Care Initiative, and a plethora of other things. So I might have her actually introduce herself if you don't mind, because she'll be in this building pretty frequently.
Great. Welcome.
Thanks. I'm really excited to join the DOC team and looking forward to meeting all of you in person sometime soon.
And how do you pronounce your first name?
Viva.
Viva?
Viva.
So we will be in contact, because I know we're going to be talking later on this afternoon about what items we want to have covered. And I know healthcare and WellPath and DEVA and Medicaid coverage and the 1115 waiver and all of that. We're very interested in. And so that would be either in August and September for us, just to give you a heads up. Anything else? Thank you. So before we break for lunch, because I don't want to lose Janine, I don't want to lose Keisha, or Trevor, Martin had to scoot out for something. He will be back. We had a conversation this morning, Janine, prior to you coming on board, about how we move forward as a committee in terms of leadership for the committee. In DOC, we're done. You get off the hot seat. I'd just like to get this done before we break for lunch for that. And I don't know, Ginny, if you want to share what your thoughts were. You and I had a conversation.
Yes, I'd be glad to do that. And I think this is obviously it's a committee decision. However, with the loss of Senator Sears, and that's pretty significant. We all know that, and we all we're missing him already, especially in this environment. He is chair of the committee. It was Senate turn for him to be chair, and Alice has been so really terrific and gracious in taking over the committee when Dick hasn't been available, and now when he is no longer here with us. My thinking was to continue as we are and have Alice continue to run the meetings as vice chair without electing a new chair. I think for me, it makes a lot of sense. I am probably the next senator on the list, just in terms of longevity. That doesn't mean that I'd become chair, and I'm certainly not asking to have that happen. What I'm asking for is for us to allow for Alice to continue as vice chair and coordinate and work with us on our agendas, and then continue until after the November election and after new appointments are made. I did raise this issue with the pro tem, and he was perfectly fine with it. And Alice, I don't know if you had a chance to talk with Jill or not.
Oh, okay.
But it is a committee decision. It's just my suggestion.
So I know one thing that was talked about this morning was Topper was saying about an interim chair, and you're saying just keep it the way it is and just have the vice chair continue in the vice chair position and do the work. Either way works, doesn't matter.
Well, yeah, no, and honestly, I'm happy to talk with you if there's a need that we can work together on that, and I think others are. I think we usually work pretty collaboratively on this committee and have similar interests. So I'm fine going forward, Allison, giving you the heavy lift.
Yeah. Irene?
That's up to you. I mean, then that's up to the folks on the committee.
Right.
Thank you. My concern would be having someone appointed to fill that other Senate slot for the remainder of this year. And I believe there are some senators with judiciary experience on the Senate committee.
You need someone from approach because Bob is here for Senate Judiciary.
Yeah, I believe there are senators on approach who could be appointed.
Have you spoken to Phil about filling that?
Yes, I have. And I think he was very happy to have us go forward with your leadership, and that he is looking to, I think, fill the slot. And I can't tell you when or who or what, but that will happen.
Yeah, that slot needs to be filled.
Okay, thank you.
For sure.
And secondly, I would like to maybe appoint you interim chair and then appoint an interim vice chair, because I think every chair needs a vice, just in case.
Need a vice.
So if we were going to consider you as interim chair, I'd like to have us consider an interim vice chair, and I would just love to have Ginny fill that role, but that's just me. So that's my input.
Well, so Irene, thank you for that. I mean, that's something we can do. Remembering that right now, this session, this term, this year, it's the Senate's role to be chair. So
Understood.
So
this would be an exception.
I don't know what law we're violating. Ben, maybe you can help us. What rules are we violating if we did it that way?
Well, so there is the statute that creates the committee in Title II, Chapter 23. But it doesn't account for an absence or vacancy from the chair position or the committee in general. There is a mandate to create rules of procedure,
which we haven't done.
So you could make the argument that this is a new procedure that's being adopted. But there's nothing that really covers this.
So I guess what's before us, I think there's agreement that I would continue being leadership of the group. The question is, do I stay as vice chair and we have slot for chairs empty? We keep it empty. I continue for the remainder of this biennium with an understanding that I'd reach out to Ginny to help with agendas and help with the committee. That's one avenue. The other avenue is what Irene put on the table, that we actually have an interim situation where you have an interim chair and an interim vice chair. You see the difference?
If I could.
Yeah, Keisha?
Yeah, I mean, if I could just add that I think this is, in my mind, over the years, this has been one of the more formal, um, you know, committees that functions outside of our regular session. And it's probably a good thing to formalize our approach to whatever we do. There's just, I think we've hit a phase in the legislature where we're seeing more turnover more regularly for whatever reason. And it would just be good to formalize whatever approach we put in place. And I would tend to agree that I'd rather just call you Madam Chair for the next several meetings, instead of interim acting vice chair. Um, and and I think it is good to have a vice chair from the Senate. And Ginny, I know you often get busy with LCAR, like of course you'd be great. I just also thought it's if Senator Norris, as the member from Judiciary, wanted to just fill that role, that's a thought too, because it was coming up about different parties, which I don't think has been given that it was Senator Sears and Representative Emmons, I don't think that was a spoken rule of any kind, but it was just sort of giving you the option to not have to take on another out of session role if you don't want one. But I do think whatever we do, we should just formalize it and recognize that it's an incredibly special case in terms of reversing the Senate and House role. But that maybe we should formalize the idea that the vice chair, should there be some kind of vacancy due to a health emergency or, a loss, the vice chair does take over for the remainder of that biennium. And that is okay to flip the balance that way.
So listen, I think that is the right way to look at it, where this is an interim step. The vice chair has been offering continuity and providing support for Dick while he was unable to be at meetings and to work with him and put agendas together. And it could be that appointments are made or an appointment is made, and then we come back and we have the discussion about election of a chair again. But right now we don't have a whole committee. So I do think it has nothing to.
Oops, you cut out. You cut out, Jenny. Maybe take yourself off a video. I don't know if you can hear us.
She said there was coming in and out.
I know, yeah. So I'm hearing agreement about an interim chair. That's what I'm hearing, I think.
And we do have a quorum to make that decision. I don't think we need to wait for every last person to get back on or in or
Right.
whatever, right?
Six.
Mhm.
Quorum of 6 people.
Yeah.
Can they vote on Zoom?
Or senators, yes.
I'm
Senators
not
can vote on Zoom.
There has to be
there has to be.
We have to make a law. We have to make it a rule.
No.
I thought it was we get,
dictated by Senate and House rules.
You can't just that.
we lost Ginny. And I thought the Senate rule was that we have 2 meetings remote where we can vote out of session. And then we have to be there in person to vote.
And I don't remember what the House was.
Give me a second to double check.
I want to eat lunch.
The House was, there was a couple of meetings you could vote.
Was it 2? I don't remember. The joint meetings. Jenny's back.
I'm here. Can you hear me?
And now, yeah, go ahead. Finish what you were saying.
My internet is going nuts. Where did I leave off?
I don't remember.
I will just say this. This is an unusual time. This has nothing to do with whether or not I would like to do the work. This has to do with providing continuity and the work that Alice was doing with Dick and Alice's leadership as vice chair, and to allow for that to continue. Should there be another appointment from the Senate, we can come back and revisit this. But I think right now it makes sense to keep going. I'm happy to help as Bob and Irene and Trevor and Keisha and Others are willing to help, and Topper, I know you're there as well. So I think everyone's, we've all worked together very well, and obviously we've got Ben helping us as well. So I just think it makes sense to keep going. I have a long list of things that I'm interested in, and I think that you guys probably do too. I think if we keep it as simple as possible, and allow for Alice to continue as in her vice chair role, and the rest of us can pitch in. And
Right, so-
I don't know, Bob, I don't know what you're thinking, or Topper.
So what you're talking about is continuing as a vice chair and not as an interim chair. Is that correct?
I am. I think it's less complicated in that way. We're not changing the sequence of chairmanship for the committee, which is this year it's Senate.
Yeah.
That's
Okay.
all.
So under the extenuating circumstances that we're in, if a motion of any kind is in order, I'd like to make it right now.
And you want a direction of what the motion would be?
Yeah, I look for direction, go ahead.
I need some more time to find the resolution,
Okay.
make sure that.
Maybe we can have lunch.
So my suggestion is that maybe save this for that discussion portion at the end and just do it right at the outset. Then I can, during lunch hour, I'll just double check those.
So you tell us how we can do it.
Yeah,
Okay,
Well, this is for voting
for voting
on
on
Zoom.
this, yeah.
On Zoom.
So,
This could be different for House members and Senate.
yeah, so I just want to double check.
Oh, right.
Yeah. So, but
Just Bob, do you have any thoughts? I don't want to. I bring the idea, and Alice and I talked about it, but I think it is a committee decision.
I don't have any thoughts on one way or the other. I mean, I can tell you that I'm hungry. But I think given the time that we got to read this afternoon, that's fine. I would yield to my senior ranking senators on screen as to which direction I'd like to go, and I'm more happy to fulfill any role that you choose, whether just remain the way that it is or whatever. I don't have any problem with it either way. Sandra Lyons.
Thanks.
Irene?
Thank you, Madam Chair. Do we have a clerk? I only see a vice chair designated on here. And again, it's really important to me that we have two people to whom to direct the leadership questions on a committee like this, on Senate, on House, just because we want somebody who's on bat and who's on deck always, just as a matter of practice. So I don't care what we call them, but I want someone, whether it's Ginny or someone else, who steps up from the Senate to be that person that has Alice's back.
and I think Jenny said that it would be okay to do that, right?
I just want to formalize the title or a
Yes.
placement.
Okay. So let's come back to this conversation after Ben's had a chance to look at the resolution for the past to see if folks that are on Zoom can vote or not. The House and Senate, so we have a House as well. So that period is not over. I think we could do it in half an hour and get back here a little bit around 1 o'clock, maybe 5 minutes after, and continue with our afternoon meeting. Does that work?
I thought you might be short.
I did.
Does that work for you folks on Zoom? Come back
Yep,
a little bit after 1.
sounds good.
Thank you. And let's